Hey everyone, Mariko Berg, realtor with Bridgewell Real Estate Group. And today I've brought on Paul Choi from Juris Notary to talk to you guys about this force majeure clause that I'm getting asked so much about. I know a lot of people think it's the be-all end-all, so we kind of want to explain what a force majeure clause is, how it applies, and kind of demystifying it as a whole. So Paul, before we get into it, why don't you introduce yourself?
Thanks for having me, Mariko. And my name is Paul Choi. I'm from Juris Notary office. Our main office is located at Coquitlam Burnaby boundary here. I want to share some information with you guys today regarding force majeure. But I do want to say that what I'm giving you today is not to be construed as legal advice. It's just sharing information. Same thing with me, Mariko. A lot of my clients been asking me about force majeure clause.
Right.
And the simplest way to think about that is it's an actual Latin word, and it means superior force, is a direct translation. Also, a lot of times it's referred as act of God, as in it's something happening that is beyond your control. Things like hurricane, flood, earthquake, and of course, pandemic could be construed as one of them as well. Mhm.
Okay, so that's what the force majeure is, and I think it's pretty clear like why people would be asking about that is because they kind of
Absolutely,
see
yeah.
it as like COVID-19. This would be considered an act of God or something that's unforeseen or out of my control. And so how can I use this force majeure clause to potentially get me out of something, right?
Hmm.
But for what I know, at least, like it's not something that's automatically in the resale contract, the standard real estate board of Greater Vancouver contract.
No.
It is in pre-sale contracts, but I guess we'll get to that a little bit later. But I did just want to talk about for those people that are writing new contracts right now, so new buyers that are entering in the market that would like to add this clause. What
Hmm.
is the safest way for them to word this so that they're covered, covered potentially?
Right. So the safest way is to obviously write it in a way that's specifically tailored to you. So if you believe that because of this, you're going to be, let's say, losing your job and have more difficulty getting mortgaging, you want to mention that specifically in the contract to say that if because of COVID-19 that I have issue getting financing, then I want something to happen in the contract. And it's also really important to mention what you want to happen if this clause is triggered. So
Right.
if you have the situation where you couldn't get mortgaging when you already got pre approval already in the past, but now the situation changed and you're having trouble getting mortgaging close to the completion date, mentioned that I would like to let's say move have an ability to move my completion back a few months, or if you would like to be able to walk away from the contract, then say that I would like the ability to walk away from the contract and get my deposit back. So it's always good to be clear and mention as much detail as possible so that if something does happen, that there isn't any ambiguity that you're having to now discuss with the seller and renegotiate that portion.
Right. I think that's really good advice. And so like you said, right, making sure that act of God or that force majeure clause is inclusive specifically of COVID-19 and a pandemic.
Yep.
And I haven't heard a lot of lawyers or notaries actually bring up that you should also include, what will happen in the event that you are going to be exercising this force majeure. So um, definitely like specifying ahead of time during the original accepted offer negotiations that you want X or you want Y, whatever it is. So
Totally.
that's
Yeah.
good. And, I think one of the questions that I'm getting is that, in hindsight, everything's 2020 and, there's no way that we could have predicted needing this force majeure clause. It's not in a standard resale contract. And obviously getting a seller to accept something like this force majeure clause after you've already gone through subject removal and handed in the deposit is extremely unlikely because it
Yep.
obviously benefits the buyer. So, alternatively, I have had people asking about a frustrated contract. So can you kind of talk about that, comparatively?
Yeah. So having a contract frustrated is a common law doctrine. So that even if it's not in the contract specifically, you can perhaps rely on this doctrine to say that your obligation should be extinguished. Now, just like force majeure, you have to prove that the performance, your performance is rendered impossible. Um, beyond because of situation that's beyond your control. That's the important key though is that it has to be made impossible, not just difficult or inconvenient.
Right.
And you also have to prove that the outbreak, of course, the COVID and its consequences were absolutely beyond your reasonable foresight and skill at the time you enter the contract. So of course, this is where if you signed a contract, when the pandemic was ongoing, then you should have known that this is possibility. But if you signed the contract when this was completely before all those sort of things, then you might have a better chance of making that argument. But it's again has to be very impossible, not just inconvenient or difficult.
So then let's dive into that a little bit. Like, could you give me an example of something that, is pretty black and white and would straight up be, considered impossible versus something like job loss, which I think a lot of people are asking about?
Yeah. So because thankfully, knock on wood, in BC, we haven't had too many of these sort of natural disaster situations. There aren't that many sort of jurisprudence we can rely on to say really clearly that yes, in these sort of situation, the court said yes, contract is frustrated. In this situation, it's not. So it's kind of shot in the dark, and it's really obscure at this point as to how COVID-19 will be interpreted for these sort of contract issues. But you would imagine that more likely than not, in this sort of property transaction contracts, one of the big key thing is obviously ability to transfer uh, title, property ownership from one person to another. And in that sort of sense, of course, if the land title office, the government entity that does the transfer, legal transfer, is closed, so for us here is land title office in DC, then that would be more likely than not deemed to have made the contract impossible because you can't actually legally do the transfer anymore because the government has closed to do that. With in terms of job loss, that's the difficult one, and that's unfortunately the most sort of scenario that most of our clients are in. But it's hard to say for that. So I mean, I can't give a exact clear answer on that. But you have to consider, as I said, was that something that was foreseeable? Is that completely made it impossible for you to get financing or for you to make the actual payment ready, or whether that portion of the your ability to get the financing or not, is that even deemed to be a core issue in the contract that they will consider for the contract to be frustrated or not? Those are all questions that the court will have to kind of delve into and make any decisions on. So unfortunately, it's certainly not a get out of free jail card sort of things that a lot of people might like to think that it is.
Right. Well,
Mhm.
and I imagine too, like obviously COVID itself was unforeseen. Your point about, it being like at what point in time was COVID all of a sudden a discussion? Was it during your subject removal period or had you already handed in your deposit? But I imagine part of the issue with this financing thing or job loss kind of topic is more so that like if it was just as I want to say simple, but maybe that's not the right word. Simple as just losing your job. People lose their jobs all the time,
Mhm.
between, firm deals and the completion in just a regular market. And if it was just as simple as somebody losing their job, they can get out of the contract. I imagine that would cause a whole slew of issues in real estate all the time. So they can't really make it a norm. And I get that from the seller side of things, at least.
That's right, because the your ability to get financing or not is your ability. And it's your sort of condition and terms that it's your responsibility to ensure that you have an ability to actually give that funds on the completion date. So whether that can be deemed to be a essential part of the contract or not is even a question up in the air as well.
Right. No, that's a good point. So, okay. Well, case by case basis, everything's different and law can be kind of
Absolutely.
gray. So we get
Absolutely.
it.
Yeah.
Going back a little bit, so we were talking about the force majeure clause, and like I said, it's not a standard in resale contracts. You would have to add it in, but people that have pre-sale contracts, I think sometimes they think like, oh, there's a force majeure clause in there. It's automatic. I already know it's in there. I'm good. But obviously that's not true. So can you kind of talk to that a little bit?
Yeah, unfortunate part that a lot of buyers aren't aware of, perhaps, is that when you're doing a pre-sale contract, when you're doing a pre-sale purchase, majority of times you're going to be signing a contract that was drafted by the developer's lawyer. And of course, when they drafted their own contract, they're gonna draft it in a way that's favorable to them. So that's the whole reason why you draft the contract. And so when they drafted it, they will put a force majeure clause in a lot of times to assist them in their situation. So they will probably put a contract in there, usually to say something along the lines of, if the seller, the vendor, the developer themselves, have an issue completing this project, property, due to these sort of pandemic issues that cause a delay, then it will say that they have an ability to move the completion back as far as they need to be in order to complete it. Typically, a lot of times it doesn't mention the buyer's ability to get out of the contract. So this is where you have to be really careful in reading the contract and the clause that's in it, because if it just mentions vendor's ability to get out of contract, then it doesn't mean you also have the ability as well.
Yeah. No, that's awesome. I think that's,
Mhm.
yeah, that's something that definitely needs to be demystified, is that developers
Absolutely.
contracts typically favor developers and they're not for the benefit of the buyer. So uh,
Yeah,
the force majeure clause does not apply to all buyers in pre-sales, but check your contract, like you said. Uh,
absolutely. Yeah.
no,
Mhm.
I think this has covered pretty much everything, or all the questions that I've been receiving about the force majeure clause. So I hope that this was helpful for you guys. Force majeure, frustrated contracts. As Paul said, a lot of things are on a case-by-case basis. You can't just take this as a blanket answer. But if you do have questions, we're your real estate team. We want to help you during COVID. We want to help you moving forward. So again, my name's Marika. I'm a realtor with Bridgewell Real Estate Group. I'm happy to answer any of your real estate questions. And Paul's always happy to answer any of your real estate transaction, completion, law related questions. So thanks so much for joining me, Paul. And we will keep you guys updated with our next series. Have a good
Thanks
one.
for having me. Okay, bye. Take care.